Welcome everyone, and thank you for joining us today on Level Up Law. We're here at South Carolina Legal Services. We are leveling up your legal knowledge on the different areas of law that we practice in. I'm Susan Ingalls, Senior Staff Attorney with South Carolina Legal Services, and I'll be the moderator of the webinar today. We are joined by Legal Services Attorney Tamika Cannon and Paralegal Kathryn Sellars. They will be reviewing for you the most frequently asked questions that we get about divorce in South Carolina. Now, here's an important note about today's Level Up Law episode. At the conclusion of the presentation, our presenters will be answering your questions. So we won't be answering questions during the presentation, but we will answer them at the conclusion. Now, please keep in mind that this is general information for the public and not legal advice. You should always consult with an attorney for any specific legal issues that you have. Be sure to put any questions that you have in the question box that you see, and we definitely invite you to do that. Those questions will be answered as best we can after the recorded presentation concludes. So that will be an unrecorded portion. The webinar, the rest of it is being recorded, and that recording and the slides that you'll see today will be posted on our YouTube channel for South Carolina Legal Services later this week. But that special Q&A session will not be part of the recorded presentation, so definitely stay tuned if you want to hear that. At the conclusion also of the presentation and before the unrecorded Q&A, we will provide information about how to apply for free legal assistance at South Carolina Legal Services. Attendees will be in listen mode only for today's webcast. And again, thank you so much for joining us, and I'm going to go ahead and turn things over to Tamika and Katie. Let's get started.
Good morning. Thank you for joining us. We are glad to have you here today to discuss divorces in South Carolina. Now, when handling divorce cases, we often receive the same questions from our clients, and that is the purpose of this webinar this afternoon, is to go over some of those most common and burning questions that we receive from divorce clients. Now, before we get into the information and the questions, we need to talk for a brief moment about whether South Carolina is the proper location to file for your divorce. So, in South Carolina, there's a residency requirement, and that residency requirement relates to whether this is the proper state in which to file the divorce. The parties have to have lived in South Carolina for either 1 year or 3 months, depending on the situations. So we'll start with the 3-month requirement. If both parties live in South Carolina, then they have to have both lived here for at least 3 months. After they've both lived here for 3 months, the divorce can be filed in South Carolina. If only the plaintiff, which is the party who is filing the divorce, lives in South Carolina, but the other spouse lives in another state, it can be filed after that party has lived in this state for at least 1 year. And lastly, if you're filing for the divorce and your spouse lives in South Carolina, but you live in another state, then your spouse has to have lived here for at least 1 year in order for this to be the proper state for the divorce to be filed. So just keep that in mind. It's either the 3-month requirement or the 1 year requirement. So now before we get to the questions, we'd like to start with a poll just to get an idea of how much knowledge you, our attendees, have about filing for a divorce here in South Carolina. Katie, if you'll put up the poll, please.
Yes, ma'am. So the first poll question that we have is, irreconcilable differences is a divorce ground in South Carolina. Is that true or is that false? We'll give you about 30 seconds to respond. Okay, it looks like the poll questions are in, the responses. So it looks like 61% of you said that it was true and 39% said it was false. Tamika?
Dun, 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 dun. That is false. So irreconcilable differences is actually not a divorce ground here in South Carolina. It's one of the divorce grounds that people are more familiar with because you often hear it on TV or see it in movies, but you cannot get a divorce in South Carolina based on irreconcilable differences. So let's take a little bit of time and talk about the 5 divorce grounds that are available here in South Carolina. First, there is desertion or abandonment, adultery, habitual drunkenness, physical cruelty, and more than 1 year continuous separation. So, Katie, once these divorce grounds are made known to clients, what then is the first question that we're often asked?
So then we're normally asked, what do you have to show to be able to get a divorce on each of these grounds?
Exactly. So let's go through the 5 divorce grounds briefly. We'll start with desertion or abandonment. And to get a divorce based on desertion, you have to show that the parties have lived together for at least 1 year, that they don't intend to live together again, that one party has left without the consent or agreement of the other spouse, and that that spouse has left without justification for the parties living apart. It's very rare to see a divorce filed on abandonment or desertion in South Carolina at this time. And that's simply because we have an easier divorce ground available, which is 1 year continuous separation. And under that ground, you don't have to show the intent of the parties or justification for the lack of justification for the separation. So the next divorce ground, adultery. In order to get a divorce based on adultery, the filing party has to show sexual intimacy between their spouse and a third party, an opportunity for that sexual engagement or act to take place, and then inclination, which is a willingness to engage in that sexual behavior with another party other than one spouse. Now, sexual intimacy includes, of course, sexual intercourse, but it also includes other sexual activity, like, kissing and oral sex and other acts, in addition to sexual intercourse. Opportunity goes to the chance for the parties to be alone, the spouse and a third party, so that they have private time where they can engage in this type of activity. And inclination is usually shown by admission of text messages, recorded phone conversations, social media posts, showing that one spouse is willing to engage in this type of activity with another party.
One of the common questions that we get asked is related to sexual intimacy. So if you know your spouse is talking to someone else and going out on dates, you have photographs of them out and about with other people, can you still get a divorce on the ground of adultery, even though you don't know if they've been sexually intimate or not?
Well, again, it's very rare and difficult to actually provide proof of parties engaged in the sexual act itself. So it goes back to being able to show that they've had the opportunity to be alone and to engage in that type of behavior and their willingness to do so. But just the mere exchange of text messages or illicit phone conversations, that type of evidence by itself would not be enough. Again, you have to show that the parties have engaged in some type of physical exchange and that they've had the opportunity to actually do that in person, not just talk about it. So the next divorce ground, habitual drunkenness. In order to get a divorce based on this ground, the filing party has to show that the abuse of alcohol or drugs contributed to the breakdown of the marriage, and that drug or alcohol use existed at or near the time that the divorce was filed. It has to actually cause problems between the spouses, that drug use or alcohol use by one party.
And so the one question that we normally get asked about this is, if there's no alcohol use at all, and they're only using drugs and it's prescription drugs, can you still get a divorce on the ground of habitual drunkenness?
Yes, you can. So habitual drunkenness is actually a bit of a misnomer because, again, it does include the use of prescription pills. if they're used improperly or if they're abused, as well as the use of illegal drugs. So it's not just limited to alcohol use. Next is physical cruelty. In order to get a divorce based on physical cruelty, there has to be a showing of physical abuse that's taken place during the marriage, and that abuse has to rise to the level where it puts one party in danger of their life, limb, or health being seriously damaged or harmed. There has to be a showing of either a pattern of physical abuse or at least one severe incident of abuse. And if it's based on just one severe incident, that incident has to rise to the level of being of life-threatening incident of abuse.
Domestic violence incorporates emotional and verbal abuse. If my spouse is only verbally abusive to me, so if he's getting in my face and making me fear for my safety, but he's never actually laid his hands on me, can I still get a divorce on the ground of physical cruelty?
Unfortunately, you would not be able to. So in South Carolina, there has to actually be some physical harm during the marriage to get the divorce based on physical cruelty. And we know that, emotional abuse is often as damaging, if not more so, and even more traumatic than the physical abuse. But there has to be actual physical harm caused in order to get the divorce on physical cruelty.
Mm-hmm.
And then
Tamika,
the last divorce. Oh, go ahead.
I'm sorry. There's one more question that we often get asked. If there's been physical cruelty, physical abuse, or sexual abuse towards the children, but not the spouse, can you get a divorce on physical cruelty based on the abuse towards the children?
No, you cannot. The physical abuse has to actually be directed towards the spouse. So abuse of other family members would not qualify a person for a physical cruelty divorce. And so the last divorce grounds is more than 1 year continuous separation. And in order to qualify for a divorce based on this ground, the parties have to have lived together or lived separately, for at least 366 days.
Okay.
That's the qualifying factor for that divorce ground.
So Tamika, if a spouse has been in jail for the last 4 years, let's say for domestic violence, and when he gets out of jail, he comes and moves in with the other spouse, can you still get a divorce on 1 year separation based on the 4 years that you were already separated?
You can't. If the parties stay together, even one night before that 1 year passes, they have to start over. So that one night would make the parties ineligible for that 1 year divorce. It has to be 366 consecutive days that they have lived in separate households.
Okay.
So let's talk about some other common questions that we receive related to divorce.
Yeah. So we get a lot of questions about service, but one of the most common ones is, do you have to know where your spouse lives in order to be able to get the divorce?
Yes, generally you do have to know where your spouse lives because your spouse is entitled to be served with a divorce complaint. He or she has a right to know what issues are involved in the case and that the case has actually been initiated. And so you need his or her address in order to provide proper service of the pleadings on your spouse. There is a process called publication, where a party can be notified about the divorce by publishing the summons in the newspaper in the county where the spouse was last known to live. However, an attorney is definitely needed in order to serve your spouse by publication. And there are a number of steps involved in getting permission from the court in order to serve your spouse by publication. So you have to take steps to find him or her, such as, by contacting friends or relatives, attempting service through the police department at your spouse's last known address, doing a search of the local jails and hospitals. And then if you get approval from the court, then you can provide that notice through the newspaper. So generally, you do have to have an address.
Okay. Well, that leads us to our next most common question, and that's, how long does it take to get a divorce? But before we get into the answer for that question, we have another poll question for you.
Okay.
True or false, divorces can be finalized within the state of South Carolina within 30 days. And we'll give you about 30 seconds to answer. All right, it looks like the votes are in. 25% of you believe that yes, divorces can be finalized within South Carolina within 30 days, and the other 75% believe that it is false. Tamika?
That is false. So, by statute, a divorce can be granted based on 1 year continuous separation within 30 days after the case is filed. However, that never happens. I've never had a case end within or right at the 30th day after the case is filed, even if it's filed on 1 year separation. For all other divorce grounds, desertion, adultery, habitual drunkenness, and physical cruelty, the divorce cannot be finalized before 90 days after the case is filed. And there are lots of factors that will impact how long it actually takes for the divorce case to finish from the date that it is filed. So, for example, if there are issues that need to be resolved in the case, such as custody or child support, division of property, debt, alimony, etc., the case will take longer. And if the parties cannot agree on those issues, then the parties will have to go to mediation, which will further delay the case ending. Also, another factor that will influence how long it takes for a divorce case to end is how long it takes to find and serve the other spouse. So from the date the case is filed, if the spouse is filed or is served, or if he or she accepts service, within a couple of days, from the date that they are served, they have 30 days to file an answer. And nothing can be done during that 30-day time period. If it takes longer to serve your spouse, again, that will influence how long it takes to finalize the case. So depending on the divorce grounds, it generally will take several months, usually anywhere from 3 months and longer to finalize a divorce case. Also, the county in which the case is filed will impact how quickly a final divorce hearing is scheduled and how quickly it can be set. And lastly, the final divorce hearing has to be requested within 365 days from the date the case is filed. So that is a bit of a guideline for how long the case can stay open. And if the final hearing is not requested within a year of the case being filed, it will be automatically dismissed by the court, meaning the case will basically be thrown out. So what are some other questions we received, Katie?
Does my spouse have to agree to the divorce?
Yes. No, the spouse does not have to agree to the divorce. There's nothing for your spouse to sign regarding the divorce in terms of whether or not they agree. So no signature is required.
Another question. Oh, here's our poll question. Before we get to the poll question, another question that we do get is what if your spouse doesn't come to the final hearing?
So if your spouse does not come to the final hearing, it just makes it easier for you to get the relief that you are seeking. So the hearing will still go forward as long as you have provided the proper notice to your spouse of the final hearing. It should not delay the case if that proper notice was given. So you can still proceed even if your spouse does not appear. So what's our poll question?
So our poll question is, a final hearing does not need to be held if a spouse does not respond within 30 days to the service of the complaint. Okay, we'll go ahead and close the poll. It looks like 13% of you said it was true and 87% said it was false.
Good.
Tamika?
So the majority has it here. That is false. So a final divorce hearing does have to be held, whether your spouse agrees to the divorce or not. In order for the divorce to be finalized, the final hearing has to be held. The family court judge has to grant and approve the divorce, and a written order has to be prepared, signed by the judge, and filed with the court. even if the parties go to the final hearing and the judge says, I grant the divorce, the parties are still married until the final divorce order, again, is prepared, signed by the judge, and filed. I always advise my clients after the divorce not to go out and get remarried until they have the signed divorce paper in hand. I actually had that happen recently where an opposing party got remarried a few days after the first divorce hearing. That second marriage was not valid because his first marriage had not yet been dissolved. What other questions do you have for me?
Do I have to have a witness to get a divorce?
So generally, you do have to have a witness to attend the final divorce hearing with you, and the witness is there to support your divorce ground. So if you're asking for the divorce on 1 year, that person, is there to explain to the judge that he or she knows that you and your spouse have in fact not lived together in more than a year. If you're asking for the divorce on physical cruelty, your witness will come in and testify about any abuse that he or she heard or saw firsthand between you and your spouse, or the aftermath of that abuse. Say if he or she witnessed bruises on you, or they heard a physical altercation between you and your spouse. Now, there are some exceptions to that rule about a witness being required. Depending on the circumstances, if there is other supporting evidence, for example, if physical cruelty has been involved and one spouse has been criminally convicted for that abuse, a witness is not needed under that situation. For example, if you have a spouse who has been found guilty or pled guilty to domestic violence first offense, you don't need to have someone else come in and testify about that abuse. Also, under some rare circumstances, a witness is not needed if it's clear to the court that the parties are not colluding or coming together and providing testimony just so they can get a divorce more quickly. Again, that's very rare for that to apply. And the rule of thumb is that you would need to have a witness to come to the final divorce hearing with you.
Okay. And do I have to have an attorney to get a divorce?
So no, you don't have to have an attorney to get a divorce. There are actually some resources available to get a divorce in South Carolina without the assistance of an attorney. The Supreme Court website that we have listed here has free packets that are available if you want to file and qualify for a divorce based on 1 year separation, when there is no property involved, there are no minor children, debt, or alimony to be addressed. Legal Services provides free in-person clinics. We're not offering those now, just currently due to the COVID-19 pandemic, but we are offering some of those clinics online where an attorney presents the information in the process and all of the forms and explanations to file for the 1 year divorce separations where there are no children, property, debt, or alimony or division of property to be addressed. Now, if there are issues that are contested in the case, it is advisable to have an attorney under those circumstances. And one resource to find a private attorney who can assist with divorces and family court cases is the South Carolina Bar's Lawyers Referral Line, and we've included their contact information there for you as well. So that's what we have for you this afternoon. These are the questions that we receive in virtually all of our divorce cases, and we hope that this information has been helpful for you. If you all would remain on the meeting, we will answer some questions that were submitted before the training started today, and then any that we received via the chat this afternoon. And this time we will turn it over to our moderator, Susie Ingalls.
Hey, I want to thank Tamika Cannon and Katie Sellars for a very informative presentation today on divorce in South Carolina. And let me also thank all of you who joined us today. We really do appreciate your interest in this subject matter and all the others that we cover on Level Up Law. Right now, I'm going to give our audience some important information, but do please remember, as Tamika mentioned, to stay tuned after I complete that information when they will be doing an unrecorded portion of today's presentation to answer your questions. But right now, I want to be sure that everyone knows that Level Up Law is a series of free legal events to educate the public on some of the most commonly faced legal challenges that we see here at Legal Services. You can join us every Tuesday at noon to learn the basics of a particular topic, as well as how to avoid pitfalls and protect yourself. You can find this episode from today and all of the previous Level Up Law webcasts on our YouTube channel. So just go to youtube.com and search SC Legal Services and just go to the playlist section and you'll find our Level Up Law playlist. Be sure while you're there to like and subscribe and sign up for those alerts so you'll always know what's coming up next. Just give us a day or two to get this one uploaded and then you can listen again. Now, if you have an issue and you need legal assistance and you can't afford a lawyer, you may be eligible for our free legal representation. You can see here on the screen how to get in touch with us. We want you to apply for help here at South Carolina Legal Services if you need to. You've got the toll-free number, 888-346-5592, between the hours of 9 and 6, Monday through Thursday. Our intake office personnel are always standing by during those times, but remember, you can also apply online on our website, and that's a great way to do it 24/7. Again, we at South Carolina Legal Services, thank you for tuning in to Level Up Law, and we do hope that you will tune in next Tuesday when we will be talking about adoption in South Carolina. And again, an easy way to see what's coming up each week is to check out our South Carolina Legal Services Facebook page, or always you can follow us on Twitter and Instagram. Now, that concludes today's webinar, except for our question and answer portion, which we will start momentarily, and we look forward to having you back with us next week.
Thank y'all.